Hi, my name is Hosea Masinga and I'm a case officer at the National Consumer Tribunal. Today I will be advising you on how to file an application to compel the production of a statement in terms of Section 114 of the National Credit Act. This type of application is filed by the consumer directly to the tribunal. The purpose of this application is to compel the production of a statement of account that is not offered or delivered upon request of the consumer within a time as determined by the Act. The tribunal may, on application by the consumer, order the credit provider to provide the statement or determine the amounts in relation to which the statement is sought. There are limitations in terms of Section 107 of the Act, in that Section 114 does not apply to developmental credit agreements to the extent determined in Section 107, subparagraph 4 of the Act. In the case of joint consumers or guarantors, the statement required under the section may be given to one of them, but a joint consumer or guarantor who may not have received the statement may require the credit provider to deliver a duplicate of that statement without any charge. The projected table is an overview of the processes involved in a Section 114 application. The first step being the filing of the application by the consumer, who ensures the compliance with the filing requirements of the tribunal. Thereafter, the tribunal screens the applications, and if all filing and compliance requirements are met, a notice of filing will be issued to the parties. Thereafter, the respondent has 15 business days to answer to the application, and the consumer has 10 business days to reply to that answer from the date the answer has been received. And that is the pleading stage. Once pleadings close, the tribunal will set down the matter for adjudication. The consumer and the respondent are required to attend on the hearing date. Thereafter, a ruling will be issued. If it is refused, the matter is finalized, and if granted, the next step applies, which would be pleadings for merits. This process is the same as the pleadings process above. However, pleadings open from the date the leave to refer ruling is issued. Once merit pleadings close, the tribunal will set the matter down for hearing. Parties are to be present to argue their respective cases, and the final judgment is issued by the tribunal thereafter. There are certain instances that impacts the usual process, such as other interlocutory applications, which means any applications that must be argued prior to the next stage of the process identified in the previous slide. Common examples include the late filing of affidavits, applications to amend documents, and failure to meet filing requirements. The projected table is a step-by-step guideline on how to file a Section 114 application. These guidelines are guided by the tribunal rules, which are available on www.thenct.org.za. There are certain documents that are required to file a Section 114 application, as required in column D and E of the previous table. These documents are as follows: the Form TIR30A, the Form TI114, a copy of the credit agreement, and if available, a copy of the most recent statement. Also, if applicable, a copy of the applicant's written request for a statement. Personal service requires that the person signing for receipt must include their name, surname, and designation. Courier service is a form of personal service, and in addition, you can serve via email, thereafter follow that up with personal service to expedite. This is, in instance, file after personal service was done. With regards to email service, consent to service must be received prior to filing the application. Consent must be specific and relevant to the service of the application. Service by registered mail can also be done. The registered mail slip must be stamped and dated. Should the service avenues not apply, contact us for further assistance. The consumer must serve all the documents in columns D and E to the entity that the complaint is leveled against and all other parties affected by the order or the relief sought. What we do when we receive your documents is that we screen your submission and decide to issue a notice of filing. That is if we are satisfied with the submission. Alternatively, we reject your application with the guidance on how to file your application in a manner that the submission will be accepted. We do this to ensure that you are able to provide us with all the relevant information for the tribunal to adjudicate on your case. And that, good people, is how to file an application to compel the production of a statement in terms of Section 114 of the National Credit Act. I thank you.